Tax Bar, I welcome Mr. Murari, Senior Advocate, to give us insights on the very major issues of the Companies Act. Welcome, Mr. Murari. You have taken your time, and I know you're very, very busy. It's very, very nice of you to have accepted our invitation. Please, you can start the slides share.
Thank you, Narmada. Of course, the very, very busy part is not really very accurate now because we're all under lockdown and have quite a bit of time on our hands. But let me thank you and the organizers and everybody else for giving me the opportunity to share a few thoughts with all of you. What has happened is these particular provisions of the Companies Act, which I propose to deal with, are matters which used to be dealt with regularly before either the CLB or after that before the NCLT. Now, with the advent of the IBC, the NCLT has got flooded with and really swamped, I would say, with IBC work. And therefore, they really don't have the time to take this up on a regular basis. Therefore, I think this is really an opportunity for me. The last 3-4 years, we haven't done anything major on this. So I actually look at this as a good opportunity to revisit and relearn some things which I had learned earlier and forgotten. Now, therefore, if there is something here which I've forgotten in this whole process, please forgive me for that. We'll try to. So can I'll start by, you see, basically this part of the presentation I propose to break up into 3 parts. The first will be on provisions and issues in the Companies Act 2013, and my entire presentation is going to be based only on the Companies Act 2013, on the rectification of the register, the transmission of shares, and the rectification of the register. What are the rights of parties? What are the issues that arise, etc., etc. The second part will be on the provisions relating to oppression and mismanagement, because I think that also makes a interesting discussion, because there's a lot of law on it and how it's developed and what the provisions of Companies Act. Subject to time being available, we'll also look at mergers and amalgamations, and then hopefully we'll have time for some question and answer session. I don't think I'll more than a question and answer session. I think we can have a discussion, because all of you are also well versed in all of these things. We could have a discussion between ourselves on all of these aspects. So I'll start with the first part of it. And of course, like any other lawyer, I tend to keep speaking without a break. If I'm running out of time, Aparna or Narmada, anybody will let me know when I need to. Please apply the guillotine and stop. So we'll start with the first part of it, which is rectification of register, and let's look at some of the issues which arise and which are likely to arise in this context. Could you please go to the first slide? I'm sorry, the second slide after this. Yeah, this, I'm not going to spend too much time on it because this is basically procedural. And these are the requirements of Section 56 of the Companies Act for a transfer of shares and securities to take place. The reason why I'm bringing this up is basically I'm making a distinction between the transfer of shares and the rectification of the register of members. Now, shares, like any other goods, are actually movable property. In fact, they are described as goods under the Sale of Goods Act, and are transferable by the execution of a share transfer deed and given to a buyer along with the share certificate. That's how the transfer actually takes place. It's a sale of property. The minute these two are executed and delivered to the transferee, the property in them passes to the transferee. However, what really happens is, in the context of the Companies Act and in the context of the company per se, it's not aware of this transfer having taken place, because this is between 2 groups of shareholders. It may happen in a stock exchange, it may happen as a private transfer, or in any other method through a depository, which we'll be discussing a little later. But once this takes place, the company is not made aware of it, and therefore it becomes necessary for the company to recognize this transfer, register it. Only then will the transferor's name be deleted from its books and the transferee's name incorporated in its books. The importance of this is this, that for a person, a member, to exercise rights over his shares, and basically these are threefold. One, and the main thing, is to receive dividends. The second is to attend general body meetings of the company. And the third is to vote on the shares. Now, for any of these to happen, the register of members of the company should reflect the name of the transferee as a member. Only then he can recognize these rights. Please go to the next slide. Now, once this transfer happens, vis-a-vis the company, what is the position? That is considered in section 56 of 58 of the Companies Act. I'm sorry, 58(1) has not been included into this PowerPoint, but I'll deal with that because that's a significant feature of this. Section 58(1) of the Companies Act deals with private limited companies, and it provides that a company may, in pursuance of any power and its articles or otherwise, refuse to register a transfer. This is the first part of section 58. And this deals with a private company. It doesn't deal with a public limited company. We'll come to that a little later. Now, before getting into this provision, there's one issue I need to point out, and that is that these provisions for refusal to register were originally found in section 155 of the Companies Act 1956. It then got metamorphed into section 111 because with the CLB taking over this jurisdiction from a court, this provision got shifted to section 111 of the Companies Act. And therefore that dealt with all issues relating to registration of transfers, private, public, etc. Thereafter, it was felt that there are two requirements. One is, as against a private limited company which can have restrictions on the power to transfer, a public company has no such rights, and we will look at that presently. Secondly, we had the Depositories Act which came into force, as a result of which shares ceased to be, shares in listed companies, ceased to be in physical form. You no longer had to hand over a share certificate and a share transfer deed. It was all done by a record being maintained by a depository. What we did was you signed something like a check and transfer the shares to the transferee. It got recorded in the books of the depository. Now, this is a further subsequent development. And therefore, to cover these issues, 111 got split into two, 111 and 111A. 111 dealt with private companies, 111A with public companies. And the grounds relatable to a public company were very limited. In fact, it dealt with only two things. One is a violation of law was primarily the reason. Because this is a subject matter of a number of case law which dealt with whether a public company was helpless in refusing to register a transfer unless it violated some law, or could there be some further development to it. There have been judgments back and forth. There have been judgments of the Bombay High Court and of the CLB here in Chennai following the Bombay High Court and differing from certain other high courts, to the effect that 111A refer to certain provisions of 111. And therefore, it was held that the rights available under 111 in relation to a private company were also available to a limited extent in respect of a public company. And there was a lot of back and forth on that. The law was not fully settled, I would say, insofar as that is concerned. In the meanwhile, the 2013 Act got enacted. All those old provisions were repealed. And you had two new provisions, which are 58 and 59. One would have expected that 58 would deal with private companies and 59 with public companies, as was there in the original provision. However, this is not the case, because you'll find in 58, there's a back and forth between a private company and a public company. And when it comes to 59, it just says company, which means that you could possibly cover even a private company, though if you look at the provisions technically, it may not apply to a private company. So that is the genesis of these sections. So with this background, if you look at section 58(1) of the Companies Act, it relates exclusively to a private company and says a private company has the power to reject the registration of any transfer of shares, provided it has power either in its articles or otherwise. I mean, otherwise is really a extrapolation. We don't have any specific provision regarding otherwise, but let's look at the articles. Now, in a private company, you will have a restriction because the basic requirement of a private company is that the share that has to be a restriction, or there will be a restriction on the right to transfer. So if you look at the articles of a private company, primarily you will come across 2-3 situations. You will come across a situation where shares are freely transferable between a member and his close relatives, son, wife, daughter, father, mother, etc., etc. There's really no basis. This is what you normally find in an article. You also find an article which provides for free transfer between members. So if some person is already a member, it's open to one member to transfer his shares to another member. But if these two are not the situation and you propose to transfer it otherwise, then the general provision available is that you will inform the board of directors of your right to, of your intent of transferring your shares. Now, when you inform the board generally will make an offer to all the shareholders to buy these shares, all the existing shareholders. And if all of them accept it, it will be distributed pro rata. If some of them accept it, pro rata between them, or if it's just one shareholder, obviously all of it will go to him. There will also be a mechanics of valuation of that, namely you will get an independent chartered accountant to value it. So you have 3 situations. You have a transfer between close relatives, you have a transfer between members, and a transfer which requires the consent of the board. Now, in the last situation, obviously, if the board has found a member and has directed the transfer between member to another member, which it identifies, there can be no right thereafter the board to refuse to register the transfer, because the board has been involved in the process of getting the transfer or putting the transfer through. But if there was a transfer between, say, a person and his close relatives, or a person and another member, or a person may transfer to a third party in violation of this article without informing the board, then the board would have the right to stop the transfer or refuse to register the transfer. So you will have a second provision in the article. The first is a provision which permits the transfers. The second will be a provision in the articles which provides the circumstances under which the board can refuse to register the transfer. Generally, you will find that a transfer between a person who, say, adjudged insolvent, who is guilty of having committed a criminal offense, who is an undesirable person, and finally, you will have an omnibus clause which also says that if, in the opinion of the board, the transfer, it is not desirous that the transfer be effected to such person. Now, that person could be a member. The question is, can you then say that he is not a desirable person to acquire these shares? The answer is yes or no, because if he is already a member, the question of his being an undesirable person may not arise. However, the situation would be different if he's a member, but post his acquisition of membership, he is found guilty of, say, misfeasance, malfeasance. Generally, he is defrauded third party. He's defrauded the company. He has acquired the property of a company at a value which is unrelatable to the market value. Then, in those circumstances, the board does have the right to interdict and say, sorry, we are not accepting this transfer in favor of this particular person because he is guilty of this particular action. Now, unfortunately, what has happened is a lot of these private companies are family companies. They're small family companies. And in these family companies, however much you want to segregate the family from the membership of the company, it's not always possible. So you'll also very often find that directors of a company exercise rights of refusing to register a transfer for issues which may relate to their private equation with the member as a family member and not with regard to his action as a shareholder or director of the company. So this is the position insofar as this happens. Now, assuming that the directors do refuse to register the transfer, there is a requirement that within 30 days, they must inform the transferor and transferee that they're not putting through the transfer. They will also have to indicate therein the reasons why they have not put through the transfer. This last becomes important because the shareholder, the transferee of the shares, gets a right to approach the NCLT challenging the decision of the board. So he must know the reasons, because then the NCLT is given the has the power to go into the validity of those reasons and see whether they're arbitrary, perverse, irrational, unrelated to the company, etc., etc. We'll be looking at that provision very presently. But for this reason, it is essential that reasons for the refusal be set out in the notice to both the transferor and the transferee, saying why they have refused to register the transfer of shares. Now, subsection 2, which you will set out, starts with the word, without prejudice to subsection 1, the shares of a public company are freely transferable. I really haven't been able to understand the reason why the without prejudice has been included, because subsection 1 relates to a private company and subsection 2 relates to a public company. They're two different genres altogether, and the rights and of both of them are different. But nevertheless, you find this provision that without prejudice to that, shares are freely transferable. Now, what does this mean? Is it this? All it means is that you cannot have a provision in the articles which restricts the free right of transfer of the shares, and neither can a company refuse to register, a public company that is, refuse to register a transfer of shares between a shareholder and maybe even a third party. You really don't have a right to say why this transfer should not take place, except in a limited circumstance, which I'll be dealing with when I come to section 59. So therefore, shares are freely transferable. Now, this section contains a proviso which says that a contract between two or more persons in respect of a transfer of securities shall be enforceable as a contract. The reason why this provision was really put into this section, this wasn't available in section 111 or 111A of the 1956 Act. This has been introduced into the 2013 Act. And there's a reason for this. What really happened is there were several private agreements between shareholders, private company, public company, etc., in which they agreed that if a particular shareholder was going to transfer his shares, he would give a right of first refusal to the other shareholder. He could not transfer it to third party. He was bound to give a right of first refusal to the other shareholder. Now, what would happen if the shareholder went and transferred the shares in violation of this provision? If that transfer came before the court, before the board would have to register it. Board was not entitled to say that the transfer is in violation of a private agreement, because as far as the board is concerned, it is governed by the Articles of Association of the company. And the Articles of Association don't contain any such restriction. In the light of that, the board was bound to register the transfer. Now, this issue of what was the power and right in relation to a company came up for consideration before the Supreme Court. Ultimately, it went from the Madras High Court, but ultimately it went to the Supreme Court. It's a judgment of the Supreme Court in V.B. Rangaraj's case, which is reported in volume 73, Company Cases, page 201. Now, there was a private agreement between two groups of shareholders. Now, this private agreement was not reflected in the Articles of Association of the company. So, one shareholder went to court saying this transfer is invalid because it's in violation of this private agreement, and therefore this transfer should be stopped, and they register rectified, reflecting my name as a transferee of the shares. The Supreme Court said that as far as the company is concerned, a private agreement between two groups of shareholders is of no consequence. The only question is that restriction found in the Articles of Association of the company? And if it is not found, there's no such right which can be enforced. Now, this created a lot of complications. And I'm sure that all of you who have been engaged in drafting share purchase agreements and shareholders agreements would have included a provision. It's a provision which is included because of this law that the transferee will cause the Articles of Association of the company to be amended, reflecting the restriction on transfer contained in the shareholders agreement, and only then will the investment or the purchase take place. In other words, this was made a condition precedent to the registration of the transfer. Of course, this has its own problems because an amendment to the Articles of Association requires the passing of a special resolution. So you'd have to convene a general body meeting of the company. You'll have to get 75% of the shareholders to approve the fact that A has a right of first refusal in respect to the shares of B. Now, possibly because of these difficulties, this provision has been included as a proviso to Section 58(2), which says that this shall be enforceable in terms of a contract, which means that if there is such a right of first refusal and a shareholder was threatening to violate that right and transfer his shares to a third party, then the shareholder who's aggrieved by this action could sue for specific performance. He could ask for specific performance of the agreement, saying these shares shall be transferred in my favor. Now, it could not be a defense. It would not be a defense to this action to say, sorry, this restriction is not found in the articles, you can't enforce it. The proviso, I think, covers this situation. And therefore, this is possibly one of the ways by which you can enforce such a right. So therefore, today, in the light of this section, it is possible for a transferee who has a right of first refusal or some such right, tag along right, drag along right. There are so many such rights which to enforce such right in the event that the other party was threatening to violate. Now, there is a third example of what is called transmission by operation of law. That's also covered by 58(1), which is a transmission by operation of law. We've looked at transfer, which is a voluntary transfer between two people. Transmission by operation of law is generally found in a transfer post the death of a shareholder. It gets transmitted in favor of his legal representative. That's a general circumstance under which a transmission takes place. Now, could the company refuse to register the transmission from the shareholder to his legal representative? It could, if it had a power in its articles. It could say that this legal representative is not a desirable person because he has been guilty of misfeasance, malfeasance. I don't want him anywhere near my company. Because all of these would have to be established with cogent reasons, and it has to be substantiated. It can't be undertaken for any ulterior or external motive. That's the basic requirement of this. Now, what happens if a company, and we're looking here at a private company, what happens if a private company, in exercise of its powers, refuses to register the transfer? What is the right available to the transferee? Because he has now bought the shares for valuable consideration. he now has with him share certificates which don't carry any right vis-a-vis the company because the company has refused to register it. So therefore, what is his rights? His rights are to make an application before the National Company Law Tribunal, the NCLT, under section 58, subsection 3. Now, this is to be done within 60 days of the intimation of the refusal, 30 days from the receipt of notice, or 60 days from the date on which you lodged the date on which you lodged the transfer deed with the company. So you have to make an application, and the application, the tribunal could, after hearing parties, it can dismiss it. You can say, fine, I think the refusal to register is perfectly valid, or it can direct the transfer or transmission to be registered, or it can direct the company, and in fact, it's a third thing, to direct the company to rectify its register, incorporating the transfer, and also pay damages to the party because the refusal by the company is for completely, what shall we say, arbitrary and extraneous reasons. So it could also provide for damages. So these are the rights available to a transferee in a private company to get his name registered in place of the transferor. Now let's look at the other situation in relation to primarily a public company, but it also, from the description in the section, it looks as if it will cover a private company also. We have seen 58, which deals with refusal to register. You don't even come on the register. There is a converse situation where you come on the register and you get taken out of the register. Your name is incorporated in the register, and you will find that it is taken away from the register. That is covered by section 59 of the Companies Act. A name which is included gets taken away. The second situation is default or delay takes place in entering your name in the register. In all of these cases, it will be section 59 of the Companies Act which would apply. And likewise, if the person agreed could you can go to the next slide. No problem. Thank you. You can the person aggrieved has a right to file an appeal to the National Company Law Tribunal, challenging either the removal of his name from the register or the delay and default in entering his name on the register, and that's covered by section 59. Now you will notice one thing in both section 58 and section 59. The words used are without sufficient cause. So the refusal to register is without sufficient cause, which you will find in section 58, 4, which deals with a public company refusing to register. You will also find it in section 59, which deals with removal of the name or default or delay in taking the name. The question is, what is sufficient cause? Now, there is no hard and fast definition. The question is, what is a sufficient cause is a question of fact in each case. A decision has to be taken with regard to what would be a sufficient cause. For example, in say a public company, will the question of a public company having refusal without sufficient cause, when would it arise? And what would be the sufficient cause in relation to a public company? And what would be the sufficient cause in relation to a private company are probably two different aspects. But when we're looking at, say, at a public company which refuses to, which either does not include the name or removes the name or delays and defaults in entering the name, the primary sufficient cause could be that this shareholder could be a person who's in direct competition with the company. He's a person who's trying to acquire shares in the company with a view to gain a foothold into a competitor. Or he could have a conflict of interest with this company. Now, in any of these situations, the inclusion of his name certainly is not in the interest of that company, because or maybe it's a direct competitor, and maybe you would not like the affairs of this company to be disclosed to the other, because it's always possible to ask for information, because once you become a shareholder, you get a right to ask questions at the meeting. And if at that meeting certain questions are asked with relation, say, the marketing network or so many things, the companies may have to answer it. Of course, in some cases they refuse to answer it. But if you do answer it, you're actually allowing a competitor to get some kind of information into the inner working of this company. May not be in the best interest of this company. And in those cases, sufficient cause is available, and you could still refuse to register the transfer by reason of there being sufficient cause in refusing to take such action. So these then will read, and of course here again, if you file an appeal, the NCLT is given the power to enforce this right. It can direct the transfer. And you will also notice that there's one other provision here which deals with the refusal to transfer, which I'll point out for the purpose of completeness of narration. And that is section 59(4), which provides that a transfer which is in contravention of 2-3 acts are named therein and says any other law for the time being enforced, then the concerned person, who could be either a member, could be the company, or it could be a depository, because here you're finding one situation of a depository having the right to apply to the NCLT, saying, please remove the contravention and direct the rectification of the register. Or if it's a direct contravention, then rectify the register, remove the name, because a person has acquired shares in contravention of some law. Now, for example, you have things like the takeover regulations which have been formulated by SEBI. Now, if you violated, say, the takeover regulations and you acquired shares, which the company may not be immediately aware of, then you have a right to apply to remove it. Now, here you have one other situation. Insofar as a public company is concerned, you have two separate kinds of shares. One are physical shares, for which you deliver the share certificate along with the transfer deed. Or you have the dematted shares. What are fungible or dematted shares, in which all you do is you don't physically transfer shares, you transfer it through by signing something like a challan, and you transfer it and it gets recorded in the records of the depository. It doesn't go to the records of the company. It goes to records of depository. And in terms of section 88(3) of the Companies Act, that is the equivalent. No, you won't find it here. So you can. This is the equivalent of the register of members of the company, and therefore the transfer gets recorded in the records of the depository. Depository may not be aware of certain inner issues in relation to that particular shareholder. So therefore it gets recorded. 1 month later, maybe the depository will give intimation to the company that we have during this month recorded all of these transfers. Then the company knows that this transfer is in violation of a particular provision and therefore ought not to be done. The company will then either refuse to take this transfer on record, or having taken it on record will remove his name from the register of members and inform the depository accordingly. In these circumstances, this application under 59(4) will apply, where even the depository is entitled to move the NCLT, requiring that the contravention be set right, the register be rectified, and if the contravention in fact is so blatant it cannot be set right, then obviously the transfer cannot take place and the company will be justified in refusing to register the transfer. Now, these are the issues primarily which relate to the transfer of shares and rectification of the register and the rights of a transferee primarily in moving moving the NCLT to get this register. Let's now come to the second, the next right of a member which relates to the issues of oppression and mismanagement. Now, these are found in sections 241, 242, etc. of the Companies Act. And these are, the equivalent was sections 397 and 398 of the 1956 Act. These have come into this with some modification, which I'll come to very presently. Now, before we get into the meat of this section, let's look at section 244 of the Companies Act, which sets out the basic requirements which entitle a person to maintain a petition under these sections. It's not that all and sundry can file it. There is a basic minimum requirement for filing it. And the reason why this basic minimum requirement has been set out is because you can't, otherwise in a company with lakhs and lakhs of shareholders, you will have 5 disgruntled shareholders dragging the company to the NCLT for every small thing. So there is a basic minimum requirement. Basic minimum requirement is either 100. I mean, looking at a company which has a share capital. So either 100 members, 1/10 of the 1/10 of the number of members, or 1/10 of the capital of the company. In other words, 10% of the paid up capital. That's a paid up capital of a company, which will include equity shares and preference shares, or 1/10 of the total number of members, or 100 members. These are the people who can move the NCLT and ask for relief against acts of oppression and mismanagement, which the majority have probably, as shareholders or through acting through the board of directors, have been resorting. Now, before we get into the requirements of that, I think we can look at the proviso to this section, which gives the power to the NCLT to waive the requirements of this minimum percentage. Now, this requirement is available. You can move the NCLT saying, I don't have 10%, I have 6%, I have 5%, or we're not 100 members, we're 50 members. But look at these set of circumstances. Please waive the requirements of section 240 and permit me to file this petition. Earlier, what was happening is, it was a two-pronged thing when it was before the CLB. You had to move the central government, ask for waiver. If the central government waives it, then you come before the CLB and then you file an application and say it's been waived, so I'm filing it. But that has now been given to the NCLT, and probably rightly so, because why have two sets of personnel, one to waive the requirements and the other to hear it? You have just one tribunal now which will decide to waive it or not to waive it, and the other will, and the same tribunal will hear it on merits. Now, question is, can you just waive it? I move an application, say, please waive it. Now, can you just waive it because I've asked for it? This issue arose in the Cyrus Mistry case, because that is a case where Cyrus Mistry, who moved against Tata Sons, did not have 10%. Now, he wanted the provision, the requirements of this provision to be waived. And he moved the NCLT in Mumbai, saying, please waive it. These are my grounds of oppression and mismanagement. I have substantial grounds to file such a petition. Please permit me to waive it. The NCLT refused such waiver and dismissed his application. He moved the NCLAT, the appellate tribunal, challenging the decision of the NCLT. Now, the NCLT permitted it, they allowed it. They passed a very detailed order allowing the waiver and laid down certain parameters. It doesn't mean that you can waive it without looking at these parameters. They've laid certain parameters saying what you can do and what you cannot do. Now, what you can do, in fact, what you should do, and what you're required to do are fourfold. One is, first find out whether these people who applied are actually members of the company. They will have to satisfy you that they're in fact members of the company. They will have to produce proof share certificates or the filings with the ROC or any other record to show that they are members, recognized as such as members of the company. So that's the first requirement. Now, the second requirement is look at the allegations in the petition. Don't decide the merits. Don't look at the merits of it. Do the allegations in the petition constitute allegations of oppression and mismanagement? Now, you have certain parameters of oppression and mismanagement, which we're going to look at very presently. But when you're looking at this application, find out whether the allegations made, you're not going into the it's correct or not, the truth of it. Are these substantial allegations which relate to the oppression and mismanagement of the company? They're not allegations which are DOS, oppression, mismanagement, or something else. Look at it and find out whether they're oppression and mismanagement. Now, third thing which you'll have to look at is, have you made out exceptional circumstances justifying the waiver of this? The reason for this is 10% is a norm. 10% of shareholders can take you to court. Now, if you're going to reduce that requirement and permit a lesser number, there must be exceptional circumstances available which permit you to be taken to court by the lesser number of members. And therefore, this is the third requirement which you have to look at. The fourth requirement, which is also very important, is whether there's already a petition pending against this company in which similar allegations of oppression mismanagement have been made. If there is such a similar application, has it been disposed of, or is it pending? Because if either of these situations are present, you will not be given leave, because there's already a case pending in which these allegations are going to be gone into. At best, you can say, include me into that. You can't now ask for the filing of a new petition, and therefore, in these circumstances, you will not be permitted to file this petition. So these four requirements are to be looked at. Now, what is not to be looked at? Merits of the case. Primarily, you cannot look at the merits of the case. You cannot even give a prima facie view on whether the allegations are valid allegations or not. This is where the fine distinction has to be made between finding out whether the allegations constitute oppression mismanagement and whether there is even a prima facie correctness or truth in those allegations. The first you'll have to go into, because that's a requirement. The second, you shall not look at how far are these allegations meritorious, because that's a matter to be decided after you've heard the company and after you have granted leave and in the course of the interview. So that's something you have to then look at. The law of limitation is applicable to petitions filed before the NCLT and appeals filed before the NCLAT. That is, a limitation act is made applicable. Therefore, you cannot go in to see whether this is barred by limitation or not, because that's, as we all know, limitation is a mixed question of law and fact. It can be decided only at a later stage when the petition is actually taken up. Now, you cannot go into the issue of whether it relates to the affairs of another company. You cannot go into whether there's an arbitration clause in either the articles or an agreement which constitutes one of the documents on the basis of which the petition is filed, and whether the matter actually has to be referred to arbitration or can be heard by the NCLT. You cannot go into that, because ultimately the question is, if the company does not challenge the jurisdiction of the NCLT, does not move an application on Section 8 saying refer it to arbitration, it's the NCLT will have jurisdiction. So you can't decide that even as a threshold. Directorial companies is another issue, because what happens is the basic requirement of a 241 petition is it should be qua shareholder or not qua director, and I'll give you the exception to that a little later. It is possible that the allegations are directorial complaints, relates to my position as a director in the company and not as a shareholder. So that issue again you can't go into at the threshold. When you can go into a directorial complaint, I'll point out a little later. Because even in a main petition, you can't go into it, except in a limited circumstance. The fifth thing that you cannot go into it is a question of conduct of the applicant. Because the basic requirement of 241 is you must approach the court with clean hands. Your conduct should be above board. Of course, today with the COVID, all of us sanitize our hands. We approach the court with clean hands. But be that as it may, the applicant should not be guilty of any conduct which will prejudice, because ultimately this is a discretionary relief. It's not a mandatory relief, it's a discretionary relief. If you want to get the benefit of this discretionary relief, you must show that your conduct has been above board. If you have participated in some of the actions which you are complained of, if you signed a balance sheet and then you question saying that the balance sheet is bad, it shows some inflated figures, but you've signed it, then you will, your conduct will disentitle you from maintaining the petition. But that's not something that you can decide at the threshold. That has to go on to the main petition. The other issues which can't go into are issues such as acquiescence, waiver, estoppel. Question is whether you've waived by your conduct, you've waived something, you've acquiesced, or you're stopped from making this. Are matters which you cannot go into in the other threshold. Now, before parting with the threshold and going into the meat of the section, so to speak, and I'll try and finish in the next 15-20 minutes because that's the time available. There is one other requirement which is of significance, and I'll tell you why it has a certain amount of significance. That is the fact that, let's assume that you have a minimum threshold, which I just pointed out, and you're not seeking a waiver. You also have a right, supposing let's say 100 members are to make this application. Now, the application is made by 25 members. It is possible for this 25 members to obtain the consent of 75 other members and file this petition. Or if I don't have 1/10 and I have 1/5, I can get the consent of the balance 1/5, make up 1/10 and file the application. Provided a consent is obtained. That's also provided for in subsection 2 of section 244. Now, what is this consent and how is it obtained is very interesting. And the reason why I'm getting into this, because there has been certain law, this law actually which has been laid down to the Madras High Court. It was refined by the Madras High Court way back in 1980 or so, right from 78 to 1980, and it has held the rules throughout. A lot of laws have been following it, but this is a basic law which has been laid down. So what is this consent? I'll read the section and you will note an interesting distinction that the section has made. Subsection 2 of section 244 says, where any members of the company are entitled to make an application under subsection 1, that is for oppression mismanagement, any one of them having obtained the consent in writing of the rest may make the application on behalf of all of them. So you will find two distinct words are used. My entitlement must be to make an application. But if I have obtained the consent of the balance members, I have to make the application. Now, what is the distinction between these two? Now, this came up in a very celebrated case way back in the 1970s, which is MC Doraswamy with his Shakti Sugars, where certain cane growers who were shareholders moved an application against Shakti Sugars. They had obtained the consent of certain other members which they filed along with the petition. Now, Shakti Sugars challenged the consent, saying that this consent is not for filing of this petition. They have not said what they've consented to. They've only said I consent for the filing of an application under Old 397, 398. There's nothing to show that they've applied their mind to this particular application, which is actually being filed. Because when you consent to an application, you're actually consenting to the one which is actually filed. Because that alone is a consent. It has to be an informed consent. This contention is accepted. Single judge of the Madras High Court, Justice Ram Prasad Rao, as he then was, who in spite of being the #2 judge in the High Court, still sat in the company court, accepted this contention, rejected the petition. Matter was taken up on appeal before another very illustrious division bench of Justice Ismail and Sethuraman. It's been reported in volume 50, Company Cases. I'll give you the page number a little later, where the division bench made a very interesting observation. They said there's a distinction, because it says the application. It was then, of course, the petition, but I'm now using the word. And it says an application. There it said a a petition and the petition. Because here you have an application and the application. It was originally a petition and the petition. So they said there's a very clear distinction between the two, which means that you must be able to establish that the shareholders who gave their consent to the making of this particular application which are now presented. How do you do it? You can do it in two. You can append the petition, draft of the petition to the consent, which shows that this is the petition that they've consented to. The second thing you can do is, in the consent, you must say that I give consent for the filing of application for allegations ABCD and for reliefs ABCD. So you must identify the allegations and the relief, or you must actually append the petition. Since that didn't happen, the division bench accepted the judgment of the single judge, dismissed the petition. So the reason why I'm bringing this out is there is a requirement for consent, but the consent is not just a consent, it is a consent to file the application, which means a particular application which is placed before the court. Now, this is the requirement of a consent. Let's now look at the substantive provisions, which are 241, 242, etc., which deal with oppression, mismanagement, and I'll point out the distinction which is come in, the new provision which is come in, which makes a substantial difference to the law which existed earlier. Now, 241, 1A deal with cases of oppression. 1B deals with cases of mismanagement. Now, let us look at 241, 1A. It talks of the affairs of the company have been or are being conducted in a manner prejudicial to public interest, manner prejudicial, oppressive to either the member or to any other member of members, or prejudicial to the interests of the company. So there are three requirements. One is it should be in a manner prejudicial, oppressive to the member, prejudicial to public interest, or prejudicial to the interests of the company. There are three particular situations under which you can move it. Now, the basic requirement of 397, 398 as it existed, and you have a line of cases starting from old English cases right to the most recent case on 397, 398, which said this: the acts complained of must continue till the date of filing of the petition. It has to be a continuous course of conduct. It can't be one isolated act. It has to be a continuous course of conduct which continues till the date on which you made the application. Can we go to the next slide, please, if you don't mind, where you have this? Yeah. Now, this course of conduct has to be continuous, which is why the words which originally existed 397 are the affairs of the company are being conducted. So this was what is interpreted to say are being conducted means the conduct must continue till the date when you actually file the petition. And it must be a continuous course of conduct which continues till the date of filing of the petition. What happens to a single act? Now, there was a lot of controversy over it. Let's assume a single act is an allotment of shares which is intended for completely collateral purposes. You find that the value of this is what was happening throughout when you had the real estate boom. You had companies sitting on large parcels of land. You had them suddenly finding out that the value of the company lay in the land and not actually in the manufacturing activity. And therefore, one group of shareholders would allot shares to themselves, suddenly become a huge majority and try to encash on this thing. So it's just one act. Now you're saying you're talking about a continuous course of conduct. How is one act to be challenged? So there was a small refinement which was made to this provision, which says that continuous course of conduct, saying that if there's one act, but the effect of that act continues till the date when you file the application, you could still challenge. So this is one refinement which was made by case law, which said that, okay, you don't have a continuous course of conduct, it's one act. The effect of that one act continues till the date when you actually file it. You could still maintain this application. So that made a change to it, but still it created problems because what really happened is you will have to, it could be an act, the effect could have ceased sometime in between. The shareholder comes to know of it much later. and he tries to file the petition. He is non-suited, saying, sorry, we are not here to wake up the past, but to redeem the future. That was the mantra of 397, 398, saying, the idea is not to wake up the past, but to redeem the future. Unless we show continuous course of conduct whereby we redeem it in future, we are not interested in going into this. So that used to be the difficulties which members used to face, because there was a lot of lack of transparency in the running of these companies, a lot of non-filing of returns with the rest of companies, and all of this manipulations used to take place. So therefore, when 241 was enacted, these words have been acted: have been or are being, which means that you could possibly include now past acts also. These past acts, which have ceased to continue, but which will fall within the meaning of an oppression, as I'm going to come to now, could still be challenged. You don't have to establish that it is being conducted till the date of the petition. And that's one significant departure which has been made. You can now look at past acts which are oppressive in nature, and you can still challenge it. The only requirement being now, since the Limitation Act applies, you should establish that your cause of action is still alive. In other words, you're filing it within 3 years of that action having taken place. That's the one limitation which you will find insofar as this particular provision is concerned. But now this is something which you can still maintain. Do I still have some time to go on, or a little bit? 10 minutes is okay?
Yes, sir. Yes, sir.
Okay.
Continue.
All right. I'll just go on for about 10 minutes just to finish this subject, and then we can. The second part is mismanagement. Now, this has two requirements. One is that a material change must have taken place in either the directorship of the company, or the ownership of the company shares, or in its membership. And as a result of this change, the affairs of the company are likely to be conducted in a manner prejudicial to public interest, or the interests of its members. Sorry, not public interest, prejudicial to interests of members or class of members. So therefore, you will find that the first part of it deals with what has happened. That is, a material change must have taken place. You can't say a material change is going to take place. Material change should have taken place. But as a result of the material change, you anticipate it is likely that the affairs of the company will be conducted prejudicially. So in these circumstances, you could still move an application under 241(1)(b) saying remove this obstacle. So therefore, you have oppression and mismanagement. Now, before parting with oppression, I need to point out one thing, that merely because an action is illegal, it is not per se oppressive. There's a distinction between an oppressive action and an illegal action. What is illegal is not necessarily oppressive, because you have other remedies against illegal actions. What is legal is not necessarily not oppressive. So it could be perfectly legal and oppressive, or it could be illegal and still not oppressive. This distinction, if you won't mind, with this requirement, and this is a requirement which has been brought out in ancient cases like Shanti Prasad Jain, as well as a judgment which again went from Madras High Court, the Needle Industries case, which ultimately went to the Supreme Court, and a lot of provisions of law have been settled. In the Needle Industries case, it's a matter which went through the Madras High Court single judge division bench, ultimately in Supreme Court. And when we come to the reliefs now, I'll point out one other salient feature which Needle Industries set out. But Needle Industries sets out this position that if it's legal, it's not necessarily not oppressive. It could still be oppressive. Or if it's illegal, it doesn't automatically become oppressive. But they also added this caveat that a series of illegal actions could conceivably constitute oppressive conduct. Now, 242 deals with the reliefs which an NCLT can grant in cases of oppression and mismanagement. And that's the next slide. Now, in order for an application to be, for orders to be passed or directions to be given, two requirements are to be satisfied. That is, the company's affairs have been or being conducted in a manner prejudicial, oppressive or prejudicial, which we read out. That's the first requirement. You must find out whether oppression or mismanagement actually exists. That's the first requirement for the grant of the relief. Second requirement is merely because you come to this doesn't mean you'll give you relief. The NCLT has to come to the conclusion that this company requires to be wound up on the ground that it is just and equitable to wind up the company. This requirement is still available in the Companies Act, the grounds for just and equitable. Of course, you have a substantial amount of judgments on what is just and equitable, starting from Raghunath Prasad Jhunjhunwala's case. But the NCLT has come to conclusion, yes, it is just and equitable. The conduct of affairs of company renders it just and equal to wind up this company. But if I did that, it will unfairly prejudice the member of members, and therefore I'm exercising my jurisdiction under this clause. These two requirements are to be satisfied before any relief can be granted. For the first to be satisfied, companies' affairs are being conducted oppressively. The basic requirement has been laid down in all of these cases is that the conduct should be harsh, burdensome, and wrongful. This is an extraordinary remedy. So you can't do it as a matter of course. The act should be harsh, burdensome, and wrongful. In other words, there should be an element of lack of probity, of good faith, unfairness, etc., for the NCLT to come to the conclusion that the acts are oppressive in nature. So that is the first requirement to be satisfied. Second requirement is just and equitable that will be wound up. When do you come to this requirement? That there are two groups of shareholders. One group cannot get along with the other group. That there is a complete deadlock in the management of the company. For example, if you have two groups of shareholders holding 50-50 and they're fighting with each other, there's no way this company will survive. And it can't really, that the substratum of the company is gone, or any other extraordinary circumstances which will depend on the facts and circumstances of each case. So in any of these circumstances, it would be just and equitable to wind up the company. Now, if it is just and equitable, what does the NCLT do? For example, if there's a deadlock, you have the powers which are, we have an omnibus power which says that take such action that makes such orders the NCLT deems fit to bring an end to the act complainant. So this is basically an unlimited power. You have all these cases, Bennett Coleman, Gordon Woodruff, and Rakra Sports, which say that the power of the NCLT is unlimited. The only limitation being that it should be aimed at the objective for which the section is enacted, namely to put an end to an act complained of. Whatever relief you grant should be with the intent of putting an end to the acts complained of. That's the only limitation which can be recognized for the NCLT's powers. And of course, you have a subsection 2 has a without prejudice and a number of requirements, which I'll come to very presently. But before I do that, there's one other aspect I need to bring out. Supposing the NCLT does not find conduct oppressive, does it mean that the petition will have to be dismissed as such? They will automatically dismissed. One would assume so. One would assume that if you don't satisfy these two requirements, because two requirements are there for granting relief, let's assume you don't satisfy the requirements. What does the NCLT do? Does it just dismiss the application? The answer is yes and no, because in normal circumstances, it should dismiss it. However, the Supreme Court in Needle Industries said that notwithstanding all of this, nothing prevents the NCLT or the CLB or the court as it then was to pass such orders as it deems fit to do complete justice between the parties. So you could still do complete justice because it's an equitable relief. You could still do complete justice between the parties, and you still have powers to pass such orders. Now the question is, what is the scope of that? Could anything be done? Because in Needle Industries, Supreme Court passed such a direction. Now there is another judge. There was a petition filed in respect of a company called Bharati Cotton Mills, where the CLB, following the Needle Industries judgment, did not find oppression per se, but still directed because it was a 50-50 shareholding, it said the one shareholder will buy out the other. Now, that was challenged before the Madras High Court, and then the Supreme Court saying that no case of oppression has been made out. You could not have granted such a relief. When it came to the Supreme Court, Needle Industries was placed before the Supreme Court to say, look at the principle laid down by the Supreme Court, the idea is to do complete justice between the parties. The argument was that was an order by the Supreme Court acting in its extraordinary powers under Article 142. This could not be granted by the CLB. The Supreme Court said no. We have not said it's confined only to us. 397, 398 or 241, 241 provides that a court or a tribunal seized of the matter can still do complete justice, bring about justice in the matter, do complete justice between the parties, though technically you don't find a case of oppression. Now, subsection 2 sets out the release which an NCLT can grant, including directing a company to buy its own shares from the shareholder. You can either direct a member to buy the shares, you can direct a company to buy its own shares. Normally, a buyback under the Companies Act has a huge procedure involved. Now, this provision cuts through all the process. An order of the NCLT directing company to buy back its shares is a direction to it to buy back, regardless of whether those requirements are complied with or not. The only other provision I'd like to point out is subsection G, which says that a transfer, delivery of goods, etc., or any action relating to property of the company made or done within 3 months prior to the day of the application can be set aside if the same is deemed to be a fraudulent preference in the insolvency of an individual. So these two requirements have been spelled out. Now, you saw 242, the omnibus provision says you can pass such orders as you deem fit. Subsection 2 is without prejudice to the generality of the power, and it circumscribes setting aside within 3 months, and the same being a fraudulent preference. So it was argued before the CLB and then before the Madras High Court that this cannot override subsection 1 because that is an omnibus power. This is only without prejudice to the generality of it, and therefore even if the transfer is taking place more than 6 months earlier, I can still get it set aside because under using the generality of the powers. The Madras High Court said no. Once you have a specific provision which says 3 months, then this 3 months has to be complied with, and this should be read into the power available under subsection 1. So, so far as setting aside is concerned, the time limit will be 3 months, and still it's not just every transfer which takes place in 3 months. It should be shown to be a fraudulent preference. That is, generally a fraudulent preference is a preference in favor of one creditor over the other with a view to deprive another creditor of the right over their property. Those principles will have to be imported into this before any relief can be granted into these provisions. Now, there are a humongous amount of judgments spelling out what would be the parameters of powers under 241, 242, etc., etc. But for want of time, I'll leave it at that. And I think, may not be able to get into the aspects of mergers and amalgamations for want of time, because this actually but that's mostly procedural, and I think the intent of those provisions is that a scheme of compromise between the company and its members and can be the thing. I'll only deal with one aspect of it. Insofar as mergers, compromise, arrangements, and mergers, you could have a compromise, you could have an arrangement with your members or creditors, or you could do a merger. Now, merger between two companies, or a demerger, which is a reverse of that. Now, the question is this: in any of these instances, an application is made to the NCLT. It was earlier to the court. Now it's been shifted to the NCLT, and an application is made to the NCLT insofar as these applications are concerned. At the first stage, a meeting is directed to be convened. The NCLT does not look at anything beyond finding out whether the scheme actually is illegal or not. I mean, that's a basic, that's only a very, very preliminary thing, because ultimately the wishes of the creators or members will have to be gone into. After which a meeting is called of the members and creators, because the provisions for waiver, but I'm getting into the question for members. Now, there are two requirements of these meetings. Majority in number, representing 3/4 in value of the persons present and voting, should have approved it in each case. Because if you have members, if you have a class of members, that class, because there could be rights which cover individual classes, creators or class of creators. In each of these cases, it should be approved by majority number, at least 51% of the person present and voting. But these 51% should have at least should represent 75% in value of that particular class for it to be done. Now, what does the NCLT do? What are the parameters which the NCLT does when it looks at this? It is not sitting in appeal over decision of the members or creators. In fact, right from the Hindustan Lever judgment, it is said that it is left to the wisdom of the members. If they want to approve a scheme which is unfair to them, who is the court to intervene with it? But ultimately, it doesn't mean that the court is a mere rubber stamp. Please go to the next slide. In Mihir Mafatlal's case, sorry, the next one, yeah. In Mihir Mafatlal's case, these provisions have been set out. This is what a court or now the NCLT should look at while sanctioning a scheme. All statutory provisions supporting such a scheme have been complied with. Requisite meetings as contemplated. 391, there's now 241 have been held. Scheme is backed by requisite majority vote. That is, majority number represents 3/4 in value. Majority decision of concerned class of creators or voters is just and fair to the class as well. That is one requirement which you need to look at, that they are not driving roughshod over the rest of them. All necessary material required under those sections have been placed before the voters. All materials contemplated by the provisions have been placed, and the scheme is not contrary to public policy, just, fair, and reasonable. These are the basic requirements which the court will look at, or now the NCLT will look at, for sanctioning a scheme. Beyond this, really the NCLT doesn't go very far to find out, sit on merits over decision of the, sit on an appeal over decision of the members and find out what is the issue. So thank you very much for a very patient hearing. That's all that I have for now. So.
Thank you, sir. Any participants who has any questions can please raise your hand. I'll mute you.